You're live. Hello, everybody. Thank you so much for joining us today for our webinar with Rainie from Tsong Law Group. My name is Chris Gao, and I'm from Family Source Consultants. And thank you so much for watching today. And Rainie, why don't you say hi to everybody? Introduce yourself a little bit.
Sure. Hi, thank you, Chris, for inviting me to join today's webinar. Hi, everyone. My name is Rainie Fang from Tsong Law Group. I'm an attorney licensed to practice in California, New York, and Oklahoma. I graduated from University of Southern California Law School in Brooklyn Law School. Our office is located in Greater LA area and is licensed to practice in multiple states. We specialize in assisted reproductive law and have helped hundreds of families achieve their goal of family creation each year. Yeah.
Got it. Got it. Well, thank you again for joining us today. Today, we will be talking about the legal considerations during surrogacy and egg donation journeys for different types of intended parents. And we get questions from intended parents all the time. Like, how do I know it's going to be legally safe and secure for me? How do I know I am going to be the legal parent, like, after the baby's born? Do I have to go through adoption process? And today, if you're watching, you will have all these questions answered. So let's dive in, okay? Can you please start with sharing a little bit about the standard, or the common legal process and timeline, what that looks like? What are the standard steps and how long it usually takes? So
Sure.
how about, how about we start with, the egg donation or the surrogacy contract? And, we all know if you're using a fresh egg donor, you need to sign a contract with your egg donor. And if you're using a surrogate, you need to sign a contract with your surrogate. How long does it usually, take to fully execute these contracts?
Sure. Yeah. So for egg donation, so the first part is intended parents need to know that they need a legal agreement to
Mhm.
make sure that their donation is protected, to make sure that after retrieval, they will be the owner of the eggs, will be the owner of the embryo made from the eggs retrieved, and
Yep.
they will be the parents of the child. So that donor will relinquish any and all rights to the eggs, to the sperm, to the embryos created. So usually I'll say that after donor is medically clear, which means the doctor thinks that donor is ready to go. So
Right.
we're going to enter into the legal process. The
Mhm.
whole legal process will take about 2 to 3 weeks. It's kind of shorter than surrogacy legal process. And for our office, usually I'll say it takes 3 to 5 days to draft an egg donation agreement. And
Okay.
so that's after the draft, we're gonna send it to our clients. Usually, it'll be intended parents. Intended
Right.
parents will review with us one on one. So that's we'll ask them, oh, how do you feel about this agreement? Do you have any questions? And if you have any like special requests, we can incorporate into the agreement for them. So that after they approve the draft, we're gonna send it to donor's attorney. Donor also has the right to review the agreement, and donor has right to revise and to make sure the agreement reflects her request in her like in her request and can limit intended parents' right of like disposal or future donation, so that
Mhm.
after both parties review with their attorney and we're gonna finalize agreement. Of course, we're gonna negotiate the changes. We're gonna finalize agreement. Then
Yep.
both parties will sign. After they sign agreement, we're gonna issue a legal clearance letter, which means your attorney make a promise to the IVF clinic to say that the parties have already gone underwent all the required legal process. So IVF clinic can start the cycle, can start the egg retrieval cycle.
Got it. Got it. So basically, in short, either the donor or the surrogate, they would not be able to start the IVF cycle until after the legal contract is finalized, right?
Yes, correctly.
Got it. Got it. Well, that is great because it not only protects intended parents, but also the egg donor as well as the surrogate.
Yes, because the law in the U.S. no state allows the purchase or sale of genetic material. So the
Mm,
agreement is an agreement to make sure that this is not a purchase or sale of genetic material, but this is a donation which is allowed by the law, so that
yeah.
both parties can be protected.
Got it. Thank you. Thank you so much for the detailed explanation. So, we know there will be attorneys involved, as you mentioned. Do these attorneys have to be licensed in specific states? Say, if they have to be licensed in the intended parent state or the surrogate or egg donor states?
Okay, this is a depends on question again. A lot of we have a lot of clients who say, "Oh, I know your attorney, but can you please give me a clear answer? I don't want to depends on question." But just say we always give our client a lot of depends on answer. Yeah.
Yeah,
So
yeah.
it's a depends on question. So first, I'll say regarding egg donation, the
Mhm.
requirement is more flexible.
Okay.
Usually, as long as the one-side attorney is licensed in the state where like intended parents will live,
Mhm,
donor lives, or where IVF clinic is located, then
mhm,
it's sufficient to use that state law. But regarding surrogacy, that's more complicated
mhm,
because for some states, I'll say for most of the states, for Indiana, Florida, Nevada, Utah, or New Jersey, as long as one attorney is licensed in that state, that's
uh,
sufficient. Then we
okay.
can use that state's law to draft the agreement to obtain the future parentage order for the client. But
Yeah.
for some states, for example, like Oklahoma, Colorado, so they still require that both parties to be represented by an attorney who's licensed in that specific state. So
Mhm.
different states have different requirements.
Got it. Got it. And so, we understand the attorneys will help draft and finalize the contract between, the intended parents, egg donors, and intended parents and their surrogate. But who will be helping the intended parents get the legal parentage after the baby's born or before the baby's born? Like, in that regard.
Mhm. Sure. So before we talked about who will help, so probably I can share because I'm not sure. Probably there are some intended parents who are watching our webinar today who have no idea about what his parentage are. So I can
Yep.
give
Yep.
a bit background information. So parentage is kind of usually it will be an order which is signed by the court. So
Mhm.
before the baby's born or after baby's born, even if the intended mother is not the one who delivered the child, but the intended parents can be recognized as legal parents who will be adjusted as to be the legal parents for the child so
Right.
that their parental right will be protected. Okay, regarding the legal parentage, so I'll say that it's a teamwork. So it's a
Mhm.
teamwork between like intended parents attorney and surrogate attorney because
Okay.
it needs both parties' cooperation. So for
Mhm.
most of the circumstances, intended parent attorney will help obtain legal parentage because intended parents attorney will send out intake to like agency, to intended parent, to surrogate attorney to gather all information they need for obtaining the parentage order. But
Mhm.
also, but I'll say for some cases, surrogate attorney will take the lead as well. For
Okay.
example, remember because for example I'm licensed in California, but I'm not licensed in Nevada. So
Okay.
when we have Nevada cases, we'll have surrogate attorney who's licensed in Nevada to take the lead
Mm,
to prepare
I
all
see.
documents. Then we're gonna just forward the document to our client to intended parents for review and let intended parents know that okay what the documents to talk about and whether they agree with it and instruct them to sign. So that's a teamwork. So it depends on whether there will be a hearing and which party's attorney is closer to the court uh,
Mhm.
if obtaining physical copy of the parentage is needed.
Got it. Got it. Thank you. Yeah, thank you so much for sharing that. And I myself, to be honest, I didn't actually know towards the end of the legal parentage state, both attorneys will be heavily involved. And I always was under the impression that one attorney will be, the main one processing the parentage, request.
Oh yeah,
Right.
yeah, sometimes one party will take the lead, but even if only one party, like only one attorney need to appear before the court to obtain the parental order, we usually still need the other party's attorney to sign some paperwork and to
Mhm.
notify the surrogate, to notify the intended parent. So that's a teamwork.
Got
Everyone
it. Got it.
got it
Okay.
out.
And next question is it's a popular one and it comes up a lot. A lot of intended parents know about the pre-birth states and post-birth states. Can
Mhm.
you just explain the concept of pre-birth and post-birth states to some intended parents who may not be very familiar with this concept, and which states require adoption after birth? Like, this is one of the questions that we get asked a lot, and a lot of intended parents care about this because they don't want to go
Mhm.
through surrogacy in a state where they have to later adopt the child.
Mhm. Oh, totally understandable. But I'll say this is the biggest question everybody
Right?
easy to answer. Of course, I can totally understand. It's not easy to answer every time, even if intended parents reach out to us and ask us, oh, which state works best for them. I'll say, oh, it's hard to say. We need to analyze where the embryo is stored, where intended parents live. Do intended parents need the second citizenship for the
Mhm.
kids? Are intended parents like are they married? Are they single? Are they LGBT couple from some state, from some country where the LGBT marriage is not recognized? So a lot of factors to consider. But overall, we'll say that pre-birth state means the parent and child relationship will be established via an order or via some sort of administrative process before baby's born. So usually we obtain parent pre-birth order around 26 to 30th gestational week.
Okay.
In case baby will be born prematurely.
Mm.
And then in those states, intended parent name will be placed on the baby's birth certificate once baby's born. So
Okay.
that's the one, which means intended parents do not need to wait a few weeks or a few months for to add their name on baby's birth certificate after birth.
Great.
So for those states, I'll say that some states that intended parents can consider is like California, Nevada, Indiana, or Texas. But Texas is a bit special because seriously, Texas is a dual parentage state because
Okay.
it can be a pre-birth order, it can also be post-birth order. It depends. So and
Interesting.
also I'll say Oklahoma is also a pre-birth state that
Okay.
intended parents can consider. But for post-birth states means surrogate name will be placed on baby certificate at the very beginning after baby's born, and then there will be another process. It could be administrative amendment process. It can also
Mhm.
be a legal process through the court to request that intended parent need to replace surrogate name and to be placed on baby's certificate. So, for
Mhm.
example, like Hawaii, Iowa.
Mhm.
So, especially for some non-genetically related intended parents, a
Okay.
post-birth parentage order is required.
Got it.
Also, I usually I'll tell our client that we want to let our client know that there are some states or state orders judgment is not required to establish their parentage. For example, Illinois or Virginia, because
Mhm.
it's possible to get the parentage order through the
Right.
court, but it's
Right.
not necessary, especially for domestic clients. So,
Mhm.
well, for example, for Illinois, we only need some certifications. It's more of like an administrative process, so
Okay.
that the client, your attorney will handle all, will gather all information and prepare documents for them to sign. They don't need to file it with the court, but they
Mm.
can get the certification, which will, upon which aims the hospital will receive those certifications and put an parent's name on the birth certificate. But for international clients, I was told intended parents that for international intended parents, probably they still need an order, even if they work with a client surrogate who's
Mm.
from a state where the parental order is naturally required. Because from our experience, for example, like China, if
Mhm.
the parents are from China, they want to get their kids travel documents to China,
Okay. Mhm.
Chinese consulate general. So
Right.
they need to show the consulate general a order from the
Mhm.
state court, which to it
Mhm.
a parentage order, so that even if Illinois state doesn't necessarily require a parenting order, we still need to obtain one for
Mm.
intended parents. So that's something intended parents need to consider as well. For adoption, I would say most of the states do not need post-birth adoption
Mhm.
unless the intended parent is not genetically related to the child. For,
Okay.
for those states, I'll say like Florida,
Mhm.
Minnesota, Tennessee. Yeah, those
Hmm.
are to say that if there are two intended parents, one is genetically related, one is not, they use some donation. So for those intended parents, I'll say that probably you need to leave some time after baby's born,
I
and
see.
because you need to prepare for post-birth adoption here.
Got it. Got it. Thank you. Yeah, thank you for explaining that as well. And now let's get a little bit more detailed because every time we have a new intended parent, they'll be like, "Hey, in my case, what works best? In my case, what
Mhm.
works best?" Right? So,
Yeah.
can you share a little bit of based on your experience, can you share some advice or just some insights for intended parents who are single, single intended
Mhm.
parents, same-sex couples, and
Mhm.
couples who are not married, who are going through surrogacy as, basically as both as parents, but, they're
Mhm.
not a married couple, and intended parents who don't necessarily have a biological link to the embryos
Mhm.
because they either use adopted embryos where a
Mhm.
sperm donor and an egg donor. What are some of the things they should be aware of based on your experience.
Okay, sure. Yeah, that's a pretty complex question because
Mhm,
not only for what types of intended parents, but also for one specific intended parents.
mhm,
So for different families, what they need to consider are totally different because
mhm,
different family has different needs and the embryo are still stored at different states. So overall, we'll recommend intended parents to talk to your agency, talk to your attorney to discuss potential match. And
mhm,
then the intended parents will have a better idea about whether the match will work for them. So
mhm,
how long does it take to obtain the birth certificate after birth, and can they get baby citizenship in intended parents' home state, home country, and how to make it happen? So I'll say, for example, for same-sex couple, intended parents, they need to consider whether the embryo shall be owned by the related intended parent or it shall be jointly owned. Because for some, I'll say like if intended parents are from some country where the LGBT couple is not marriage is not recognized. So if they are co-owner of the embryo on IVF clinic's record, probably they can only enter into surrogacy as a couple. But probably that will give them some like difficulty when they apply baby's second citizenship. And
I see.
also, there are some states they don't allow surrogacy for unmarried uh, intended parents. So the I can give you like example is like in Utah and Oklahoma. So that's interesting. Like Oklahoma, I'm licensed in Oklahoma, so I can share more about Oklahoma's cases. So Oklahoma allows single intended parent to do surrogacy there. They allow married uh, same-sex couple or heterosexual married heterosexual couple to do surrogacy there, but they don't allow unmarried couple to do surrogacy there. So it also there are some states like they only allow intended parents living in the United States to do surrogacy. For example, New York. As we all know, New York legalized surrogacy in 2020 in the last 2 years, so that their law is still developing and kind of change. So there are a lot of factors to consider. At the very beginning, New York only allowed intended parents who live in New York to do surrogacy there, but now they broaden they accept more intended parents. They say, okay, as long as the intended parents are resident in the United States, they can do surrogacy. But that which means international intended parents cannot do surrogacy there. So there are a lot of factors to consider to select the good state for intended parents.
Yeah, absolutely. Thank you. Thank you for sharing that information as well. And we did get a comment from one of the viewers that there is echo. So I started turning off my microphone when you're chatting. Rainy, just know that, if you see my microphone turned off, that's because I'm trying to avoid the echo.
Oh, sorry.
Okay. All right. So next one. Well, actually, in the meantime, we got a question from a viewer. That viewer says they are Chinese citizens. If their baby is born through surrogacy, how do they get passport for the baby? Do we have a couple minutes to address this very quickly?
I'd like to answer. So you mean intended parents are Chinese citizen, so they want to do surrogacy in the United States, but they haven't been matched with a specific surrogate who's from specific state?
It doesn't look like it. I mean, again, just based off the question, there looks like they're thinking about surrogacy in the United
Um,
States, and they're wondering how to get the passport for the baby after the baby's born.
Okay, no problem. So first, I'll say that we have a lot of international Chinese intended parents, and they successfully get first birth certificate and baby's U.S. passport, and then Chinese travel document, which means, can I say some Mandarin? 旅行证, back to China, so that the baby can be a resident in China, can don't need a visa to go into China until the baby turns 18 years old. So that really works. And I'll say that intended parents can consider most of the states in the U.S. to do surrogacy. And so for one thing I want to remind intended parents, if they are LGBT couple, is China doesn't recognize LGBT marriage. So when you consider you want to start do surrogacy in the U.S., probably the first step you need to consider is because if there are two intended parents on the surrogacy agreement, then you cannot file the surrogacy agreement with the Chinese Consulate General to get baby's travel document. So they need one. You can consider to do single intended parents surrogacy. So, but there's still another way that to make two intended parents to be parent of the child. For example, like they can get married and then they can do step parent adoption after baby's born, so that both of them can be parents and can be listed on birth certificate. His second way is in Illinois and in California, we have successfully helped intended parent who are from China to obtain two versions of birth certificate. And judge would like to help because they know that the difficulty if baby doesn't have Chinese like travel document, how can babies live in China? So they would like to help. So we're gonna receive two orders, one order listing only one parent, one order listing both parents, so that one birth certificate listing only one parent will be issued after baby's born. And then you can use that birth certificate to get travel documents into China. Then after you get all documents you need, then you can send just mail the judgment with listing both parents as parents to Vital Record, so that Vital Record will amend the birth certificate, making both parents as the parent of the child. So that works.
Got it. Thank you. Yeah, thank you so much for addressing that live question from our viewer, and I hope you find it helpful. So the next one is also a pretty popular question. Are there ways to utilize the law of a state neither the surrogate nor the intended parent live in? Like, are there ways to kind of like work around it? Because usually people know if I live in this state or my surrogate lives in that state, we probably have to utilize one of these state laws. But are there ways to work around it?
Okay, yeah, it's possible. And I'll say that whether you can utilize the law to work for you and to make it flexible and to shorten the period of time intended parents need to spend in obtaining parentage and birth certificate. It depends on your attorney. It depends on your attorney's experience, because the attorney is supposed to help you analyze which plan works best for you. I can share two examples. For example, Hawaii is a post-birth order state, which means intended parents might need to wait up to 2 or 4 months to get the post-birth order and to get the birth certificate after baby's born, which means if they're international clients, they need to stay there for quite long time for after baby's born. So that will bring a lot of inconvenience. So we have successfully used California pre-birth order to aim to be recognized by Hawaii Vital Record, and so that you don't need to wait after baby's born to get the parentage in Hawaii, but you can directly get birth certificate after baby's born, which saves much more time. And I'll say that for most of the state, they require you can only use the state law where surrogate or intended parents live. But for California, you don't need to do that. For California, as long as this is the California is the state where IVF clinic, embryo transfer is performed or surrogacy agreement is signed, baby is to be born, then you can get the order there. And then sometimes so this is why I said that sometimes we use California pre-birth order to be recognized in some other state. For example, we use California's pre-birth order for Hawaii, for Texas, so as to save, for Ohio, to save the time intended parents need to spend after baby is born. And so it's important for international client to consider how can they shorten the period of time they need to spend. And also, I'll say Washington State is a pretty flexible state. So if intended parents, I'll say neither intended parents or surrogate live in Washington, but as long as intended parent or surrogate has mental health evaluation with a Washington licensed therapist who is physically in Washington while doing the evaluation, they can use Washington law. So that's quite flexible because Washington is also a surrogacy friendly state that intended parents can obtain the order. Yeah.
I see. Thank you. The next question we get fairly often as well from intended parents. Sometimes intended parents, ask, "Hey, can we relocate our surrogate? When it gets closer to due date, and move her to a more friendly state, so the baby will be born in that state. We can utilize that state law." Is that something you would recommend at all? Relocating surrogate, during the pregnancy?
Mhm. Okay, thank you. So I think today we share a lot of experience. Like we encourage intended parents to try, like talk to your attorney, talk to your agency to try to come up with a plan that works for you. But I'll say this is a question that it's doable, but it's not strongly recommended. Sorry, it's not strongly recommended unless there's some other factors making it really, really necessary. The reason I'll say that is because see, surrogate. So for most of the cases, surrogate is covered under insurance. But you need to analyze whether if the surrogate is going to deliver in some other state, whether the insurance will cover. If it doesn't cover, intended parents might take the risk that the medical bill will be quite high. And what if there's some emergencies at the time of birth, a baby is in NICU, and surrogate is in ICU? Or those risks shall be borne by intended parents. And also, I'll say not every state law can be applied to the case, and where the only connection is baby will be born there. So there are a lot of factors. I hope that intended parents will give us a surprise that during pregnancy she said, "Oh, I come up with an idea. Let's send surrogate to some other state for delivery." I just always confirm with our client that if you have any plan, let us know beforehand. Do not give us this kind of surprise during pregnancy.
Yeah, absolutely. I totally hear you. So we did just get two more live questions from two different viewers, and they have very specific questions, I assume, about their situation. So one says, "What happens if if IP and clinic are in California, but the GC is in Florida? Do the laws of California dictate, or do the laws of Florida dictate pre-birth order?"
Okay, so we have similar match for a few times. Pretty similar match. IP live in California or IVF clinic is in California because I'll say that usually for those kind of this kind of match, we'll use both California law and Florida law for surrogacy stage. Contract stage. So that we'll under contract we'll say okay under the law of California and under the law of Florida, so that we can use those laws to protect the two state law to protect the parties' rights and obligations. But for parental stage, Florida doesn't accept out of state order, so that we cannot obtain California law, a California parental order to be recognized by Florida vital record. But Florida vital is. From my experience, it doesn't take long. So that so for this kind of case, we work with Florida local counsel so that the Florida attorney will obtain the Florida pre-birth order before baby's born.
Got it. So it sounds like when it comes to parentage, the Florida laws will dictate the birth order, right? But based on your experience, then it's not going to be a complicated process.
No, it's not. It's pretty.
Okay. All right. Sounds good. And then okay. The other live question is from a same-sex couple. They said they're a same-sex couple from Georgia.
Georgia.
Are you do you like they're just slightly concerned about Georgia being a southern state, so they are just more broadly, I think this is the more broad question for southern states, and they feel like southern states don't necessarily have a reputation for being liberal when it comes to a lot of things. So do you have any recommendations for IPs who live in Georgia or just in general other southern states, would you recommend they work with a surrogate who doesn't live in the South, or does it not matter?
I'll say that as we know that for most can I say 99% of the state, the surrogacy is legal. So I strongly recommend intended parents to consider all surrogate candidate you have received a profile from your agency to consider them. Do not disqualify them just because they're from some state you believe it's not surrogacy friendly. Because I'll say most of the states they allow you can do surrogacy there. For Georgia, I'll say Georgia if you got so intended parents live in Georgia, right? So if you happen to have a surrogate who's also from Georgia, so actually Georgia, even though Georgia is in southern state, is a south state, but it's quite friendly for surrogacy, and also it accepts other states pre-birth order. So we have experience utilizing some other states order to get recognized in Georgia. So if intended parents embryo is in some other states, we can come up with a plan which works best for the couples. So not all, I'll say like, I do not feel that southern states are not a good state for surrogacy. No.
Got it, got it. Yeah, thank you for sharing your insights, and I think that's very helpful because I do think southern states sometimes have this reputation, and we get questions from intended parents,
Mhm.
hey, like I don't want to work with a surrogate that lives in a southern state for X, Y reasons, and but the short answer I think to intended parents is always it depends on your specific situation, depends on your case, and like we at Family Source Consultants
Mhm.
always encourage intended parents to start the conversation with an attorney upfront before they're matched with a surrogate. Once they decide they're going to move forward with surrogacy, talk to an attorney right away and get educated and get the information before you make your decision to rule out some states that may actually be a good option for you, right?
Totally agree. And also, one reminder is, like for our office, we provide a complimentary 30-minute consultation for intended parents who consider surrogacy or egg donation. So feel free to let us know. Your attorney can get involved in your match much earlier than you think they could, because we would like to help our client to avoid some like problems afterwards. So if they talk to us and we can let them know, okay, for egg donation, just let one intended parent to be the recipient, so which will work better for their match or something. Yeah.
Got it. Well, so the viewers out there, you heard it. Rainey said they offer a free legal consultation. If if you have legal questions about surrogacy or egg donation, or you've decided that's the route you would like to proceed to become a parent, feel free to reach out to Rainey at Tsong Law Group and ask any legal questions you have. And last, I know we're coming towards the end of our webinar today. So last, any general advice you have for people who are considering building their family via surrogacy or egg donation?
Mm, yeah. First, I'll say that for intended parents, uh, we know family creation is a pretty big topic. They need to consider a lot, especially if they want to use assisted reproductive technology for their family creation. They need to consider a lot. But I always encourage the intended parents to consider like their future parenting plan. Whether one parent want to be parent and the other want to just be an uncle, auntie, or friend of the kid, or both of them would like to be parent, because parenting is a pretty big topic. It involves a lot of responsibility and obligations. And the second is where the kid will be raised. Will the kid be raised in a country where like LGBT marriage is not recognized, then how can make it smoother for the client, for the baby to obtain their citizenship? That's a question. So always plan ahead. And second part, I say that like we said, we encourage intended parent to consider more, like from who will be owner of the embryo, who will be owner of the egg, and whether they want to do for, especially for LGBT couple, I encourage them to consider if they have any concern about their home state's law, whether their marriage is recognized. They can use split cycle. Split cycle is, I can share one story with it. So what split cycle means, at least for our office, we only charge one legal fee for drafting two agreements for split cycle, which means two LGBT intended parents, they can share the embryo or the eggs retrieved from one egg donor. So once the eggs are retrieved, for example, there are 18 eggs, so one will get a 9, the other one will get 9. And then they can fertilize it with their own sperm so that they will end up with their own embryos. So that to make it easier for future surrogacy arrangement if single or if their marriage, LGBT marriage is not recognized in their home state. So, and also if intended parents have concern about baby citizenship and future residence, I would say that for some states, especially California and Illinois, you can consider those two states because those two states we have experienced that LGBT couple, same-sex couple, they can have two-step pre-birth order. They can have two versions of the birth certificate for the kids, so that works really best for their future plan, and the baby will not have any issue living in a country where the parents, the same-sex couple parent, the marriage is not recognized.
Right, got it. Yeah, thank you so much for sharing the these examples and stories. And we actually did get two more questions before we wrap up. I know we have a lot of questions today, right? So yeah, these two questions should be simple. So let's just answer these two before we wrap up the webinar today. So the first question is, how do you find the attorney for the surrogate, especially when he's out of the state?
Out of state, which means the surrogate, the attorney.
She does not live in the same state as the intended parents.
Okay, so I'll say that. So there are traffic attorney, there are criminal defense attorney, there are civil litigation attorney. Find an attorney who specializes in assisted reproductive law, and also you can talk to the attorney to see whether how many cases you can ask your attorney. How many cases have you handled each year for surrogacy and egg donation? What state you are licensed in? And also, you can ask, you can see whether your attorney is like in some recognized institution like state ethic or SRM or I'll say Quad A. So those organizations are also for some many assisted reproductive law attorneys are gathered. So, and also you can talk to your agency to see if your agency will recommend some attorney that they usually work with. I know the parents might feel whether there will be some conflict of interest if I would work with an attorney who is recommended by my agency. I'll say that attorney is subject to the ethic rule. We will not. So once you sign a retainer, intended parents is our client. We will only represent intended parents in work for the best interest of intended parents. So don't worry about that. And the reason I'll say that it's not a bad idea to work with an attorney who is recommended by your agency or your IVF clinic is because they know how to draft the payment schedule. They know how to work with their agency. So the communication will be easier and smoother. For surrogate attorney, I'll say usually you can if your surrogate is experienced, probably she has an attorney she would love to work with because the attorney represented her in her previous surrogacy journey. And if she doesn't have one, you can ask whether your agency can recommend one for her, or if not, then you can ask probably your attorney, intended parents attorney, can also recommend some attorney for surrogates because the intended parents attorney will know that which attorney reply fast, who's responding, and who can cooperate, and who can push surrogate to schedule a review to make the legal process proceed as soon as possible in a timely manner.
Yeah, absolutely. Well, thank you, Rainie. You kind of already answered the other question, which is what are the important things to look at in terms of finding an attorney, deciding which attorney to work with. And I thank you so much for answering these two live questions for our viewer. And I just wanted to echo what you were saying from the agency's perspective. Generally when it comes to finding an attorney for the surrogate, yes, the agency will always have recommendations for you because as an agency, we have worked with a lot of different attorneys in different states, and we will have recommendations based on your needs and based on your surrogate's needs, as well as the intended parents attorney. I am sure as an attorney, you have a huge network with attorneys in other states, and as an intended parent, feel free to ask your own attorney for recommendations. But in the end of the day, obviously the surrogate has to be on board with working with that attorney, because that's going to be someone that represents her. So that is also an important piece to consider. And in terms of things to look for, when it comes to choosing an attorney, definitely look at the attorneys or the law firm's experience and how many cases they work on and how long they have been in practice, and also talk to your agency and talk to other people who have gone through this process and see what their experience is like working with this law firm. And again, just like Rainie said, typically surrogacy agencies and fertility clinics will have recommendations for you, just because when we make a recommendation, not necessarily because like we absolutely do not get anything from the law firm. It's just purely a professional working relationship. If we make a recommendation, that's because we know a lot of other intended parents have worked with this attorney and they had a really good experience with the attorney. And we also have had very pleasant and smooth experience working with that attorney. That's the only reason we recommend certain attorneys to intended parents. And again, there are so many attorneys out there, and I'm sure some of them have not worked with their surrogacy agency. And again, just because they have not worked with their agency, it does not necessarily mean they're not a good attorney or a law firm. And do your research and talk to the people who have gone through this process. And I think that's the most important part.
Yeah, the most important thing is you trust the attorney you work with. You feel comfortable talking to your attorney. You feel that your attorney can fight for your best interest.
Exactly. Okay, thank you so much for joining us, Rainie, and I hope our viewers find our session really helpful today. And we will see you next time. And this is Rainie Fang from Tsong Law Firm. And if you are interested in surrogacy or egg donation and need legal assistance, or are looking for a surrogacy agency, please feel free to reach out. It's Family Source Consultants and Tsong Law Group.
Thank you, Chris, again for having me today. And thank you, everyone, joining us. And feel free to let us know if you have any question. We know assisted reproductive technology in the surrogacy egg donation involve a lot of topics, involve a lot of factors you need to consider. Feel free to let us know if we can help.
Absolutely. All right. Thank you, everybody. See you next time.
Bye.